let's say a buyer, you are unable to pay for it. So I'm offering, as a company, I'm offering to pay it for you in full. But now, let's say, for example, the car will be registered in both your name and my name. And then up until you have been able to pay me, that you would need to ensure that you have in a contract.
So like now, let's say if we agreed that you're supposed to pay me this amount on 8, and on 8 you don't pay me and I don't follow up.
Yeah. Yes.
I still have the right to ask for that money. I just didn't ask about it. And that didn't make a difference.
Hello and welcome back to the Sisters in Law podcast. My name is Beverly Mokaya and I'm here with
Aquila Mokaya. In this podcast, we discuss matters law.
From talking about company law, tax law, business law, commercial law, family law, employment law, you name it, we got you covered.
Remember to like, share, subscribe, and comment down below. So in this episode, we'll be discussing contracts, on what contracts are and what obligations you can get and what is important in a contract and what is the effect of getting into a contract.
So first things first, I think it's very important for you to understand that once you have agreed, because a contract mostly has two parties, except maybe if it's a tripartite, for example, let's say like a guarantee, like if there's a guarantor for something. So mostly it has two parties. And it's very important for you to understand that once parties have agreed, once parties have signed a contract, the courts cannot come in to redefine or redraft, the contract. For example, maybe if you say that this other party was unfair to me in matters, the terms that or the obligations that they imposed upon me, the court cannot come in because you guys already agreed. Yeah, two private parties agreed, and that's enforceable in law. So it's very important for you to contact a lawyer so that you can have the best terms possible, because once it's signed, that's it. Yeah.
So let's go right into it, what a contract is. Generally, a contract is just an agreement between two parties. So let's say you and I, we want to get into a business. And we decide we're going to go to the contract. Or maybe you want to employ me as an employee. That could be one type of a contract. Or even if I'm moving into a house, a lease agreement, sale agreement of property, maybe land, house, and whatnot. So ideally, that's what it is.
Yeah, agreements
between two parties, and which must have an agreement. Like if I'm disagreeing with any clause or anything that is in the contract, I should not sign. So ideally, what a contract is made of is just there must be an intent by both parties. That both of us must intend
to get into legal relations. Yeah,
because now, as you have just said, that it's enforceable regardless.
Yeah,
as long as both of us got into this contract and there was no fraud, there was no misrepresentation, and there was no unfairness before we signed the contract. Because contracts are majorly signed. They could be signed even if it's electronic signatures or whatnot. It's still signed. So that binds me and you as parties to that contract.
Yeah.
So ideally, there must be intent, there must be an offer, and there must be an acceptance. It's also important to note that in some instances, an offer and an acceptance can be put together to form a contract.
Yeah.
So there must not be like a contract that is just not like this is our contract. If there's an offer, then that amounts to an offer and an acceptance. Because if you give me an offer and I fail to agree, then I'm not bound by the terms.
Yeah.
Because let's say in employment matters, for example, you realize that other times you'd be given an offer by an employer and then you give back an acceptance which is signed by you, which might not be signed by the employer, but it's signed by you as the employee. And now you are bound to work for that person up until you guys decide to dissolve the contract.
Yeah.
So also it's very important to note that a contract must be legal. Like the substance of the contract. Let's say we are doing it's an employment contract. It has to be legal. If, for example, we want to get into a contract that talks about maybe we want to sell, let's say drugs,
Mm.
it would not fly.
Yeah,
It is not
illegal drugs.
enforceable. Yeah,
Yeah.
like illegal drugs. Sorry, illegal drugs. It would not fly
Yeah.
as a contract
Yeah.
because the major substance of this contract is illegal. Yes.
Yeah, and I think also you've mentioned something about instances where like a letter of offer and a signed acceptance would constitute a contract in itself. You find like maybe also in instances where like this example that I had, there's a company that gave a loan facility to someone to be able to buy a vehicle. Yeah, so like I think it's important for me to emphasize on the point that you said, whereby sometimes a letter of offer and an acceptance, a signed acceptance, would constitute a contract. So, like in this instance, the offer part would have the terms. For example, I'm offering you, I'm offering to pay for this vehicle, for example. You as a, let's say, a buyer, you are unable to pay for it, so I'm offering, as a company, I'm offering to pay it for you in full. But now, let's say, for example, the car will be registered in both your name and my name, and then up until you have been able to pay me, pay me back my money as a company, can you take full ownership of the vehicle? So like those are some of the terms that would be in that contract. And then the person who is being given that loan facility, quote unquote, would be able to sort of sign a letter of acceptance. Yeah, that's just another example that I've seen of where a letter of offer is and a letter of and a signed acceptance would constitute a contract.
It's very also important to note that the contract must be signed. Because now signing shows acceptance.
Yeah.
It's advisable. It's not compulsory.
Yeah,
It's advisable that a contract be typed and not handwritten.
It's also advisable for land contracts. For example, let's say if you're selling land for land sale agreements, you must have two witnesses. Like you have to have the vendor, which is the seller, must have a witness, and also the purchaser must have a witness. But with normal contracts, you don't have to have a witness, but it is advisable that you have a witness just in case you go to court and then this person says that I didn't sign, especially now if it's handwritten, because sometimes you can even have a handwritten contract. You don't have to type it.
Yes.
But it's advisable because when you go to court, we work with documents, like we work with documentary evidence. So now it's advisable if you have a witness. Let's say if you're handwriting the contract, just get two people that you know who can sign against you, so that they say that I have witnessed to this contract being signed, so that in the event that this other person comes and says I didn't sign, you can actually call your witnesses who will give an account that you actually signed the contract.
So let's go back to the beginning where we started with what contracts are and what not. We did not discuss that a contract could be either domestic, that is between two Kenyans, for example, and then it could be international. So let's say maybe it's a franchise agreement, because mostly, let's say if you want to maybe run Java here, you'd have to have an international contract. It's also important that you get a lawyer and also understand what an international contract would have and what a domestic contract would have, because there are other issues that are being raised in this contract that are different, like on issues of jurisdiction, on issues of law, on issues of currencies and whatnot.
So there are very important clauses that you need to know. And of course, consult widely with your lawyer before you sign anything. People underestimate the value of having a lawyer before you sign something, because there's something that I would be able to pick up that you might not be able to pick up. And then you might spend, whatever you're spending on your lawyer right now might look like it's a lot, but it might save you, let's say, even
Litigation.
Yeah, it will save you a lot of costs eventually. Yeah. Because you might sometimes you just sign something, like the example I've given you about the vehicle thing. You might just sign, and then later on, the vehicle gets repossessed, maybe because you defaulted on rent, on a 1 month rent or something, 1 month's rent, for example, and then it will get repossessed. And when you go to court, the courts cannot help you. Yet, if you would have contacted a lawyer before, they would tell you this is something it's not right or something. Maybe you can ask for a notice of this amount of days before repossessing, or before asking for payment on default and things like defaulted payment and things like that. So some of the clauses that are very important, without actually going into very into very specific details, would be you would want that everything that you have discussed with the other party is reduced in the contract. For example, they can't say that we had this email correspondence and this whatever we agreed on email still falls, like still stands when it's when we go to court or something like that. You want to make sure that the contract that you have is the full substance of the agreement. That you both have, to ensure that there is certainty. So there are clauses like that in the contract, and your lawyer will guide you on that. Something else that you also need to know is that you have different clauses in the contract. You want to make sure that every clause is a contract by itself.
They're all independent.
They're all independent contracts. So for example, if I have clause 1 about this, it's a contract in itself. So that if that part does not work, let's say for example, if there's a default on that part, it doesn't mean that there's that every other clause fails, because every clause is an independent contract in itself. So that's also something that your lawyer will guide you on, but it's very important to ensure that every clause is a contract by itself. And something else also would be a contract, like you said, is a collection of duties, of obligations and rights of parties. So you want to make sure that, let's say for example, if I do not insist on performance of this obligation at a certain time, it does not mean that I have forgone my rights under that clause. So these are some of the clauses that you would need to ensure that you have in a contract.
So like now, let's say if we agreed that you're supposed to pay me this amount on 8th, and on 8th you don't pay me and I don't follow up, it doesn't mean that you're not supposed to pay me.
Yes,
I still have the right to ask for that money. I just didn't ask about it on that certain date that was agreed upon.
And that would only work if there's such a clause in the contract.
That makes every clause of the contract independent.
Yes, so also, independent, and also that if I don't follow up on it, it doesn't mean I have waived my rights under it. So that's also something that lawyer would guide you on.
Also, on the issue of I had touched on international contracts. For example, it's common knowledge that our laws are totally different. So if I'm contracting with somebody who lives in Uganda, maybe even if the business is in Kenya, what laws are going to govern this contract? So that now I don't have to say that I live in Kenya, you live in Uganda, but the laws that are going to govern this contract are Zambian laws. And then now we realize that Zambian laws are unfair to me or something. So it's important that you look into the issue of having the laws, which law governs this specific contract. So that now, if there's any dispute, what law would you refer to? Because if the contract says that we are going to refer to the law of Zambia, then the court is going to refer to that law, regardless of whether the litigation arises in Kenya or in another country. So say, for example, I get into a contract with you, you're a Ugandan, I'm Kenyan, and then we say that Zambian laws are going to apply. But now we say that the court that's going to hear this matter is going to be in Kenya. We'll go to Kenyan courts, but the laws that are going to be applied are Zambian laws, because the contract is in itself a law between the two of us. Because we agreed in the contract that this contract is going to be governed by Zambian laws. Therefore, we cannot go, let's say, to Uganda and have Kenyan laws apply. So that's also a very important thing that we need to analyze in the contract.
And I think something else that we can say, just something else that we can add, is dispute resolution under contracts is very important, because of course anytime we have business relations or contractual relations, it's inevitable that disputes will arise. So it's very important for you to know what sort of dispute resolution mechanisms you will have in the contract. And like we said, you're bound by it. So for example, if under contract you say that when we have a dispute, we will refer the matter to arbitration, that means you won't go to court. For example, if you default on payment, I cannot go to court, and yet the contract states that we will have maybe a mediation or arbitration, or like those processes of alternative dispute resolution mechanisms. So it's very important, again, consult your lawyer widely, so that because arbitration in itself is very expensive. Most people don't know that, but it's very expensive. So you want to consult first widely, so that you know whether you will refer the matter to arbitration first, or you go to litigation, or you just leave that clause out completely. So it's something that you also need to be aware about.
Because also you can realize that most contracts have arbitration as a clause. Like we mostly run to arbitration, but other times we realize that the value of the contract and the amount you're going to be charged to solve the issue that has arisen
through arbitration
is going to be so different.
Yeah.
Like now the arbitration cost is going to be higher than what you're fighting for. So it's logic. Yes.
And you know, in such an instance, if you go to courts, they won't hear your matter. They will refer you back to arbitration first. So those are just some of the clauses that you would want to look out for. But then again, I insist, do not sign without, if you don't understand, because just contact your lawyer, in short. Yeah.
Also, it's important to note that if, for example, we had said in the contract that, let's use employment. We had said that I was going to be paid this amount of money, but my employer doesn't pay me, for example. So what are the recourses that I have in here? You know, like what can I do about it? So you've breached the contract idea now.
Yeah.
So
now you can go to court.
If we said again, you have a litigation clause.
Yeah.
The clause to go to court and not arbitration or mediation. Or even if you had maybe go to arbitration and then it fails,
now you can go to court. Yeah.
It doesn't mean that if you just put an arbitration clause, you cannot go to court. If it fails, you can go to court. So once there's a determination that there is breach, you can always seek for compensation.
Yeah.
Yeah. So compensation to the tune of maybe the amount of money that you are owed, maybe if it was a breach of contract that's related to funds or something. And then also you can add other damages there.
Yeah.
Yes.
So now, in short, the court only comes in after there's a breach.
Yes.
Or maybe if, like, I think you mentioned it in passing when you were starting, you said that the contract will be enforced unless there was a misrepresentation of fact. Like, for example, maybe I lied about something, and you relied on the information that I gave you, and you entered into a contract with me. That one, when you go to court, if you can prove it, then it can be sort of cancelled for that's the layperson's terms. And also, for example, if there was fraud involved, or if there was undue influence, like maybe someone like a parent forced the child to get into a contract.
Not really forced, just influenced.
Yeah, unduly influenced, by the way. Yeah, unduly influenced you to get into a contract. Then that's when you can, let's say, repudiate it. That's just a legal term when you go to court. And also, for example, if you were intoxicated, let's say I took you out and made you intoxicated to a level that so you can come and say, oh, when I signed this, I was not in the right state of mind. I didn't understand what was going on. I was just made to sign. So that way you can actually go to court and let's say, like, go now the contract will be rescinded. Let me teach you a few legal terms. Rescinded. Yeah. So now that means that you won't, like, the parties go back to how they were before the contract, they got into the contract. So that's like a short course on contracts. I really hope you enjoyed this episode and you learned a lot. You kept saying refer to your lawyer, because it's very important, because every contract is different from the next. So if you got to the end of this show, thank you so much for watching. See you next time. Remember to like, share, subscribe, and hit the notification bell. Bye.
Leave comments down below. Bye. See you next time.